Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners who want to learn more about some of the headline-grabbing issues in these areas. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Unfair Competition Committee of the Antitrust Law Section. I'm your host, Anant Raut. Today's episode is on the non-compete ban and the scope of the Federal Trade Commission's authority under Section 5 of the FTC Act. On April 23, 2024, conclusion of a rulemaking process started in January 2023, the U.S. Federal Trade Commission issued a final rule banning most types of non-compete clauses in employment contracts. The 5 commissioners voted 3-2 in favor of passing the ban, with the 3 Democrats voting in favor and the 2 Republicans voting against. For those of you not familiar, a non-compete clause is a clause in an employment contract that prevents an employee, after leaving that firm, from competing with that employer for some length of time, typically by going to work for a rival firm. The proposed ban proved wildly popular during the 90-day comment period. Of the 26,000 comments received, more than 25,000 were in favor of the ban. And this should come as no real shock. Non-compete clauses are not a polarizing issue where you would expect to see half the country out on the streets demanding more non-compete clauses and greater enforcement in employment contracts. The FTC heard stories of physicians being prevented from continuing to serve patients in their community, of an employee of a power washing company who wanted to leave and start his own independent business but couldn't for 5 years. The way the ban works is that it would effectively make most non-compete clauses illegal. It wouldn't disturb clauses for senior executives that are already in place, but it would prevent the signing and enforcement of new ones. It wouldn't disturb existing protections under trade secrets law, but it would preempt weaker state laws. And it would only extend as far as the FTC's existing jurisdiction. So industries exempt from the FTC's jurisdiction would not be subject to this rule. When the final rule was issued, a common theme in the public reaction was, wait, the FTC can actually do that? The source of the FTC's authority for issuing this rule is Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices. And the scope of that authority has been a source of controversy. In 2015, the FTC issued guidance that it would limit its enforcement capabilities under Section 5 to adhering to the consumer welfare standard, to using the rule of reason analysis, and generally following Sherman and Clayton Act case law. For champions of more robust enforcement, this willful self-restriction of the FTC's own authority was a little like Superman putting on a kryptonite vest in order to create more predictability and certainty for Metropolis's underworld. In 2021, the FTC rescinded that guidance, and in November 2022, issued new guidance on a more expansive interpretation of its Section 5 authority. Is this new interpretation of its Section 5 authority a return to Congress's original intent, or is it the administrative state run amok? And will the non-competes ban be enforceable? Joining me today to answer all of these questions is my co-host, Scott Perlman, a partner at the law firm Mayer Brown. Welcome, Scott.
Thanks, Anant. Happy to be here.
Great. Scott, who do we have on the show today?
First, we're fortunate to have 2 very distinguished panelists. Honorable Maureen Ohlhausen, who's co-chair of Wilson Sonsini's Antitrust and Competition Practice, and also a former commissioner and acting chair of the Federal Trade Commission between 2012 and 2018. Maureen has published numerous articles about antitrust law, including several on the FTC's unfair methods of competition and rulemaking authority. Second, we have Sandeep Vaheesan, who's legal director of the Open Markets Institute, which is a leading progressive think tank regarding antitrust issues. He also served as regulatory counsel to the Consumer Finance Protection Bureau and worked at the American Antitrust Institute. His writings have been published in the Harvard Law and Policy Review, Yale Law Journal Forum, New York Times, and the Washington Post. And he has a forthcoming book entitled Democracy and Power, A History of Electrification in the United States, which the University of Chicago Press will publish this December. And
Sandeep, I'm especially happy to have you on the program because there have been a couple of times when people in our bar have come up to me and complimented me on something that you've done. So I think it's just good for them to realize that we're two different people. So welcome to the show. And good to have you as well, Commissioner Ohlhausen.
Thank you.
Scott, I thought we should start by talking about what does the 2022 Section 5 policy statement on Section 5 say?
Well, under the policy statement's basic framework, it prohibits conduct that would be an unfair method of competition. So the first element is something must be a method of competition as opposed to a pre-existing market condition. Unfair conduct is conduct that goes beyond competition on the merits. And the policy statement has a test for unfairness that's based on two factors that are weighed on a sliding scale. First, the conduct has to be maybe coercive, exploitive, collusive, abusive, deceptive, predatory, otherwise restrictive, or exclusionary. Second, the conduct must tend to negatively affect competitive conditions. For example, it must foreclose competition, limit choice, raise prices, or reduce output, quality, or innovation, or otherwise harm consumers, workers, or other market participants, including competitors. Now, unlike conduct prohibited under the Sherman and Clayton Acts, the policy statement posits that Section 5's prohibition against unfair competition doesn't require a separate showing of market power, market definition, or actual harm to competition. It also says it's not required to employ the rule of reason as is under the Sherman Act. Parties have the burden to prove any justification for the conduct, but the more facially or unfair or injurious the conduct, the less likely it can be overcome with any justification. And the policy statement does give some examples of unfair methods of competition. These include practices deemed to violate the Sherman Act and Clayton Act, but also incipient violations of the antitrust laws, including invitations to collude, loyalty rebates, exclusive dealing, and conduct that violates the spirit of the antitrust laws, such as facilitating tacit coordination, price discrimination, interlocking directors and officers that are not covered by Section 8 of the Clayton Act, and discriminatory refusals to deal. Well, with that, we'll turn to Sandeep to discuss the rationale for the policy statement. Sandeep?
Great. Thanks so much, Scott. It's a pleasure to be here with you, Anant, and Maureen today. So I think the 2022 policy statement is laudable for a number of reasons, but first I should start by really crediting this Federal Trade Commission and the Antitrust Division for taking statutory text, legislative history, and case law seriously again. If you look at antitrust policymaking at the agency since the late 1970s, you're almost struck by the dearth of law. The DOJ and FTC are charged with interpreting and applying laws passed by Congress. They don't have the right to make policy as they see fit. And I think these agencies and their leadership have recognized that once again. So in both the policy statement and documents like the merger guidelines, I'm struck by the reliance on text and case law again. That's a huge improvement over what we had before 2021. As to the policy statement, I'll discuss it from three angles. So first, it's worth remembering that the FTC Act is a different statute than the Sherman and Clayton Acts. We often hear scholars and practitioners talk about the antitrust laws. The antitrust require X, they allow Y, they permit Z. But in the course of categorizing these three laws under a single header, we erase important nuance and distinctions between the three statutes. So the FTC Act has a different term of art, unfair methods of competition, than the Sherman Act does, which talks about restraints of trade and monopolization. And Congress, when it created the FTC in 1914, could have charged the FTC with simply administering the Sherman Act, which was something that was seriously debated at the time, or could have modified the existing terms of art. It could have simply added language to restraint of trade and monopolization. It didn't do that. It charged the FTC with policing and stopping unfair methods of competition. So the FTC Act is different from the Sherman Act, and it's important to recognize that. Second, the FTC Act, substantively speaking, is broader in scope than the Sherman Act. And I'll quote couple of Supreme Court decisions as well as lower court decisions that have made this point. So the Supreme Court in Atlantic Refining said it has long been recognized that there are many unfair methods of competition that do not assume the proportions of antitrust violations. The Sperry and Hutchinson case from 1972 said the FTC can consider public values beyond simply those enshrined in the letter or encompassed in the spirit of the antitrust laws. Indiana Federation of Dentists in 1986, so this was a decision from the fairly conservative Burger Court, said the standard of unfairness under the FTC Act is by necessity an elusive one, encompassing not only practices that violate the Sherman Act and the other antitrust laws, but also practices that the Commission determines are against public policy for other reasons. And the last case I'll quote is the 1984 decision from the Second Circuit in DuPont versus FTC. This is one of the trio of decisions often cited against the FTC interpreting and using Section 5 broadly. It was one of the three defeats that the FTC suffered in the early 80s when it tried to bring quote-unquote standalone Section 5 cases. And what the Second Circuit said is the FTC can attack conduct that is either a violation of the antitrust laws or collusive, coercive, predatory, restrictive, or deceitful. So this language in a decision that actually handed the FTC a defeat is fairly broad and expansive. At the same time, Congress said, you have a statute that's broader in substantive scope than the Sherman and Clayton Acts, but you have a more limited set of remedies. So the FTC Act does not have a private right of action, so injured parties cannot go to court enforcing the FTC Act, seeking treble damages, one-way attorney fee shifting, and broad injunctive relief. Only the FTC can enforce the unfair methods of competition prong of Section 5, and it has a fairly limited set of remedies. So against first-time offenders, it can only seek cease and desist orders. Broader in scope, paired with more limited remedies. Third, and this is something that doesn't feature prominently in the policy statement itself, I think there are important institutional considerations supporting the policy statement. So for all intents and purposes, in antitrust, we have a choice between administrative and judicial policymaking. And in our American system of law and policy, since the founding, some unelected official has had the authority to make policy, interpreting terms like restraint of trade, monopolization, and unfair methods of competition. This isn't an innovation of the New Deal or the progressive era. We've had administrative and judicial policymaking since 1787. If you're interested in learning more, I highly recommend Gautam Rao's work on the custom houses, as well as Jerry Mashaw's book, Creating the Administrative Constitution. So the question is, who interprets language like the phrases I just described? So on the one hand, you have administrative policymaking. What are some of its virtues? So the Federal Trade Commission is subject to congressional oversight, presidential input, presidential control, and also has to consider and respond to public input when it does things like rulemakings under the Administrative Procedure Act. Further, the FTC possesses real subject matter expertise, not only at the commission level, but among the staff who've spent years interpreting and applying both antitrust and consumer protection law. By contrast, the courts don't possess these virtues. Federal judges have life tenure. They're subject to very limited oversight. It's very hard to impeach a judge, for example. And they certainly don't possess expertise. There's much greater expertise at the FTC when it comes to antitrust and consumer protection than there is at the Supreme Court. And in many ways, antitrust law today is an outlier. We trust non-expert life-tenured judges to make policy. Compare antitrust to an area like consumer protection, energy regulation, or monetary policy. We don't trust the courts to regulate banks. We certainly don't trust them to make monetary policy. We don't trust them to regulate our energy system. We have specialized agencies set up to do those important missions. And so in a sense, the FTC is trying to create this system for antitrust. And that's certainly what Congress intended to do when it passed the FTC Act in 1914. For various reasons that we can discuss, the FTC has never quite lived up to that congressional promise, but this FTC deserves credit for trying. So I think the FTC's policy statement on unfair methods of competition deserves applause for being faithful to the law and recognizing the FTC's superior institutional standing vis-a-vis the courts.
Thank you very much, Sandeep. Well, Maureen, do you have any response to what Sandeep has said or other critique of the policy statement approach?
Sure. Just thank you for having me. Delighted to be here. These are topics that I've thought about, written on, and had to deal with as the head of an agency and an enforcement official who was bringing cases and winning cases in federal court. I certainly take issue with the idea that the FTC has previously had a dearth of law or ignored law. I think there are cases, older cases, that some people like and that they are featuring now and highlighting now, and then perhaps not discussing other cases, subsequent cases, that interpreted these authorities in a much more limited way. So I think that's an important thing to keep in mind. I actually have an article coming out on regarding the merger guidelines and why the Supreme Court has not done a lot of merger case law post the HSR Act. So there are reasons why some of the case law has shifted to the appellate courts rather than, merely looking to 50 to 70-year-old Supreme Court cases. And there are important Supreme Court cases too that I'll touch on. But talking first about the fundamental contours of unfair methods of competition. It is true that Congress gave the FTC that authority back in 1914, and that it was meant to be broader than the boundaries of the Sherman Act. I think that's correct. But you have to think about it as the boundaries of the Sherman Act as they were in 1914, right? Which had been interpreted in an extremely constrained manner. Since that time, the courts have interpreted the Sherman Act to reach a lot broader array of conduct. And I think the question is, does the intent of Congress to be broader than the 1914 interpretation of the Sherman Act mean that forever after, no matter how far the boundaries of the Sherman Act have been expanded, unfair methods of competition is forever broader than that? So I think one needs to think about those kinds of changes. I also think one must seriously take into account when the FTC has tried to use this unfair methods of competition authority in a way that exceeds where the courts have said the boundaries of the Sherman Act are, it's not been successful. It's 3 appellate cases and a district court case, Abbott Labs, that often gets overlooked. And some of the things that cause the courts to not support this broader interpretation of unfair methods of competition, I think, were not addressed sufficiently in the current policy statement. I'll also mention I also dissented on the 2015 policy statement for similar reasons. I didn't think that the statement dealt enough with the existing case law then and now. So, for example, in the Ninth Circuit decision in Boise Cascade that said the FTC didn't prove up its unfair method of competition case, said it was not supported by substantial evidence when the commission failed to provide evidence of meaningful anti-competitive effects. I think that's an important point that the current policy statement doesn't really grapple with. It wants to have much more of a per se approach to unfair methods of competition in certain circumstances. So the statement suggests that the commissioners, the FTC, can ignore justifications, can ignore affirmative defenses, that there's no weighing of any kind, and that also they don't have to show evidence of anti-competitive effects. So I think that mismatch between what the scant case law on UMC shows and the policy statement will continue to be an issue. I also think that this question of administrative versus judicial policymaking, Sandeep, you mentioned, other forms of policymaking. There's an important question that's really coming up to be very, very crucial, which is, can that be done by officials who are not removable at will by the president? That is going to be an important issue that the FTC is going to run headlong into. And the difference between, I agree that the FTC staff has a lot of antitrust expertise. I think they've done a good job moving that forward through case-by-case litigation. I think about, for example, invitations to collude. That was brought on a case-by-case basis. I think that's one area where there's agreement among many parties that is where unfair methods of competition could go beyond the Sherman Act, except now we have DOJ saying, well, it's actually prohibited by the Sherman Act. So that, I think, is a good example of where the Sherman Act boundaries continue to expand. I think it is very challenging, though, for the FTC to go back to old cases and not deal with new cases and not really seriously deal with the cases specific to unfair methods of competition, and to come up with a quite extensive list of things that it says are now and will be or could be an unfair method of competition, when that list looks like a way to sidestep what the federal courts have said are the boundaries of the Sherman Act, where you need to show a competitive effect, where things, concerns that, that impacts on competitors, right? An impact on a competitor just standing alone is not sufficient. It is, counter to the goals of the antitrust laws. We've seen that in many, many cases. So I do applaud the agency for trying to do a policy statement if it's going to try to use this broad scope of unfair methods of competition. But I do think it's going to run into some serious challenges in the courts. And when we're talking about cases like, for example, the AMG case, right? When you look at that was a consumer protection-oriented case, but it also has implications in antitrust, where the FTC was claiming, well, we have this broad statutory authority, and we can get monetary redress because we can get equitable relief. And a 9-0 Supreme Court said, you can't. We're looking at that's too far beyond the boundaries of the statute, and it also doesn't fit into the FTC Act. And I think a very similar critical lens is going to be brought to these very broad assertions of UMC authority.
Thank you so much, Maureen. And now I think it'd be helpful to our listeners to maybe have a little bit of discussion between Maureen and Sandeep. But I'd like to kick it off with asking Sandeep, can you respond to Maureen's point about whether this policy statement kind of ignores or sidesteps a lot of more recent case law?
Sure. So in many ways, the policy statement is a rather conservative document. The FTC summarized the case law, described practices that have been successfully challenged using the FTC Act in the past. The FTC didn't announce any new per se rules or presumptions. The FTC applied the law as it is, and the FTC Act decisions from the 60s from the Supreme Court, like Brown Shoe, like Atlantic Refining, have never been overturned. They might be, but as of today, they're still good law. As to the three decisions from the 1980s, they are routinely cited in the fashion Maureen offered that the FTC was smacked down by the courts. It should be very cautious about using Section 5 going forward. And they were significant losses to the FTC, but I would argue, and I reread the three decisions recently, that the FTC lost on evidentiary grounds, not on statutory authority grounds. I offered language from the DuPont decision where the court said the FTC can attack conduct that is either a violation of the antitrust laws or collusive, coercive, predatory, restrictive, or deceitful. That, to me, sounds like a rather broad reading of the FTC Act. Where the FTC failed was it didn't provide enough evidence or didn't articulate enough limiting principles to satisfy the court. So those should be treated as a lesson for the FTC. The FTC needs to do its homework before interpreting Section 5 more expansively, rather than a narrow reading of Section 5. So that's one response. As to the relationship between the FTC Act and the Sherman Act, the cases I cited are from the 1980s. So they aren't from 1914 or 1915. So the Supreme Court has recognized that the Sherman Act scope has narrowed and broadened over time, and still said, the FTC Act is broader in scope than the Sherman and Clayton Act. Indiana Federation of Dentists is from 1986. Unanimous decision from the Berger Court. I'm not citing the Warren Court from 1955 here. I'm citing a fairly center-right court for that proposition. Secondly, I also don't agree with Maureen that the Sherman Act has actually broadened over time. You could probably say that was true through the 1970s, but since the late 1970s, the court has actually read the Sherman Act more narrowly. It has replaced per se rules and presumptions with the rule of reason. And, we can debate what the rule of reason is, but as people as divergent as Douglas Ginsburg and Michael Carrier have recognized, the rule of reason in practice amounts to a standard of de facto legality. So if we imagine, the 1950s and 60s, the Sherman Act being a circle, and then the FTC Act being a larger concentric circle. Well, since that time, the Sherman Act circle has gotten a lot smaller thanks to decisions like Sylvania and Legion that have said vertical non-price and price restraints are subject to the rule of reason, which in practice means effective legality. So the Sherman Act is not broader than it was in 1960. If anything, it's much narrower. And so the idea that the FTC Act should be narrowed in reaction to a broader Sherman Act, I think, is reliant on a fundamental mischaracterization of the law. And as I said, the court has consistently said the FTC Act is broader than the Sherman Act in scope. As recently as 1986, in a decision that is broadly supported by the antitrust community and hasn't been overruled by the court since then.
So just to respond, my point was that it was the Sherman Act as interpreted in 1914, right, when the FTC Act was passed. Right. So if we're going to go back to the legislative history of that time, that's not 1960, that's 1914. And the Sherman Act is interpreted even today quite a bit broader than it was then for consistency. Regarding Brown Shoe, that's a merger decision.
I'm thinking of the other Brown Shoe case from 1966.
Oh, okay. All right. And then on your point about the evidentiary grounds, it's true. What the court said was that they didn't have sufficient evidence that the practices had an anti-competitive effect, right? So that's the evidence. That's the evidence that they were showing. And the new policy statement continues to suggest that the agency doesn't have to show an anti-competitive effect. So it will, to my thinking, that case stands for exactly the same thing. You have to show an anti-competitive effect. So I don't think that can be sidestepped. So I think that, again, the ability to kind of just pull pieces of cases without necessarily looking or, old legislative history without looking at the full picture of what were they talking about at the time, what were they comparing it to at the time, I think is important. One other thing we haven't discussed yet is the Supreme Court case law more broadly about the power of agencies to interpret statutes and how can Congress delegate its authority. Right? So we have cases like West Virginia versus EPA, where the court said, this is, the concerns about a major question, right? Or these major questions that Congress is essentially, turning over to, an agency to decide when it's really, much more of a legislative kind of power. Is there an intelligible principle? Can you find, something that says, here's where Congress really thought the boundaries were, and here is how it's told the agency to exercise those powers. And I think that the unfair methods of competition vision that's been interpreted in this will be in this policy statement, whether it's enforced in case-by-case enforcement or particularly in rulemaking. We haven't turned yet to the rulemaking, UMC rulemaking issue. It's going to have, some hard questions asked about how it comports with West Virginia versus EPA and major questions.
Yeah, so I'll quickly say that as to the relationship between the FTC Act and Sherman Act, I didn't even mention legislative history. I was simply quoting a decision from 1986, which said, the FTC Act is broader in scope than the Sherman Act. And maybe this Supreme Court will say otherwise. As to the risks for FTC policymaking, I'm under no illusions. The courts are broadly hostile to certain types of administrative activity, not all types of administrative activity. The major questions doctrine is a real threat to what this FTC, what this FCC, what a number of agencies are trying to do right now. So no disagreement there. I certainly won't pretend to assume that the major questions doctrine is a coherent one. I think it's hopelessly open-ended and subjective. And, Brett Kavanaugh, when he was on the DC Circuit, said, to be sure, determining whether a rule constitutes a major question sometimes has a bit of a know it when you see it quality. So I think you have a judge who's a proponent of the doctrine saying, yeah, there is something rather subjective about this. And I'm not going to predict how courts are going to decide MQD questions going forward. As to non-delegation, this is something that the conservative justices have been trying to revive for a while, narrow the scope for administrative decision-making. One thing I'll point out is in the course of American history, Congress has routinely delegated policymaking functions to agencies dating back to 1787. You can look at the customs houses, you can look at the PTO. This wasn't an innovation of the New Deal. And in that entire history, we're talking almost 250 years now, if my math isn't right, 230 years, court has struck down statutes on non-delegation grounds twice. There's a famous Schechter Poultry case from 1935, as well as the hot oil case from the same year. So non-delegation has been used to invalidate legislation twice in all of American history. So this court might revive non-delegation, use it indiscriminately going forward, but that would be very much a break with not just what's happened since the New Deal, but what's happened since the founding of the United States.
The know it when you see it description of the major questions doctrine, which has been floated as a potential check on the non-compete ban, is funny when you read some of the critical comments that came in during the comment period of the FTC Section 5 authority, which criticizes it for having a know it when you see it quality of their policy guidance.
I wanted to move along now to the non-compete ban. I think we have a little bit of time left to discuss that, but I'd like to get your thoughts about that because that's certainly, I think, the most discussed application of the policy statement in terms of a concrete rulemaking by the FTC. Maureen, do you see any problems with the non-compete ban?
Well, I think there's a question that needs to be separated from the issue. Can a non-compete agreement ever violate the antitrust laws? The answer is clearly yes. In certain circumstances, yes, it has been found to violate the Sherman Act. So it's not a sort of a, if you think the rule is outside the FTC's authority, that doesn't mean non-competes are per se legal. Right. I don't think they're per se legal, but they've been treated on a case-by-case basis. And look, the FTC tried to argue in the Snap-on Tools case that a non-compete ban was a per se violation, and it lost, right? It lost that decision. So the question is now, does it have unfair methods of competition rulemaking authority? So it set forth this unfair methods of competition rulemaking policy statement. And now it is saying that it has authority to promulgate rules that prohibit certain behaviors and also has the authority to preempt inconsistent state laws, right? Which is quite a broad authority. For many years, the FTC claimed it didn't have unfair methods of competition rulemaking authority. It had done some combined rules, and one of those came before the DC Circuit in the National Petroleum Refiners case, which was a combined unfair methods of competition and unfair and deceptive acts or practices rule. And that case, which is a case in a single circuit, suggested that the FTC had broad rulemaking authority. And so the question is, sort of what happened after that? So Congress took action and it promulgated the Magnuson-Moss Warranty Act, clearly gave the FTC the authority to promulgate unfair rules prohibiting unfair and deceptive acts or practices. It made it a more complex process for the FTC than notice and comment APA rulemaking. It has a lot of extra steps and some extra things that the FTC has to show. So the question is, did the FTC maintain unfair methods of competition rulemaking authority? And again, this was just a single circuit case. And I believe that, since Congress didn't, it said, Magnuson-Moss doesn't impact any FTC UMC rulemaking authority. It didn't say it had it, didn't say it didn't have it, just it doesn't affect that. So the question is, under today's approach to statutory interpretation, would a court find that Section 6G of the FTC Act grants the FTC fairly strong powers to engage in this kind of rulemaking? So when we see cases like the Supreme Court AMG's case, which looked at very carefully at what the FTC's authority was and where it fit into statutes, when you look at cases like Whitman versus American Trucking Association, where the Supreme Court said Congress doesn't hide elephants in mouse holes. You don't find a very, sweeping authority in some, very sort of off to the side part of the statute. I think there are some real, I don't think the FTC is going to be found to have this authority to engage in unfair methods of competition rulemaking. I also think that the agency will run into West Virginia versus EPA challenges because, again, this is a very impactful rule. The rule itself talks about the big impact on the economy. It's a rule where the states have, typically been the actors here. And I also think there's a question of the FTC's authority to preempt all the states on this. That hasn't gotten that much attention yet. So I do think it's quite an uphill battle. And one other thing that I do want to mention about this is I've been a long time student of the FTC, and there are risks to the agency for taking on this, big type of rulemaking project. When the FTC tried to pass the rule on the consumer protection side, which was called the KidVid rule, which was actually post-Maxim Moss, Congress was so unhappy with it that the agency was shut down. It lost staff. So there are risks greater to the agency than simply losing a case. So I think it'll be, interesting to see what happens. Obviously, there are challenges to the rule going forward in the Fifth Circuit. But I think it's going to be, given modern statutory interpretation, Supreme Court case law on this, it's going to be very difficult for the FTC to show that it has unfair methods of competition rulemaking authority sufficient to ban non-competes as an unfair method of competition. And it is a ban on it, right? It's not, there's no weighing or anything like that. So it's pretty impactful.
Sandeep, your thoughts on the...
I'll start with the rule itself. FTC staff deserve great credit for exhaustively reviewing the literature on the incidence and effects of non-compete clauses. They weren't cherry-picking the evidence. They looked at both the research finding adverse effects on workers and small business formation, as well as the research finding that these contracts might have benefits for employers in the broader economy. The FTC considered it all. They really covered the waterfront in this 570-page notice. And I think critically, the FTC examined how these contracts work in practice, as opposed to sort of simple law and economics fairy tales about how employees and employers might bargain over terms of employment. The FTC, I think, quite correctly found, these contracts are used as mobility deterrence devices. Most employers don't ever anticipate going to court to actually enforce a non-compete, except when it comes to senior executives, highly paid professionals, small subset of the workforce. The FTC also carefully considered the counter arguments. It did not dismiss the importance of employers being able to protect things like trade secrets, investment in worker training, and customer relationships, and said, yeah, these are legitimate business interests, but firms have other means of protecting them, including trade secret law, non-solicitation agreements, even NDAs. And then, of course, employers have full autonomy under this rule to retain staff by paying them well, treating them with respect, and rewarding good work through regular raises and promotions. So the FTC took the less restrictive alternatives analysis very, very seriously here and said, actually, non-competes aren't needed for the ostensible purpose that employers use them. Maureen mentioned the Snap-on Tools case. This is a case from the 1960s. That case concerned non-competes in the context of the franchise relationship and said, the FTC cannot declare non-competes between franchisors and franchisees as per se illegal. This rule, importantly, does not cover non-competes in that context. Commissioner Slaughter pointed that out in her remarks at the commission meeting announcing the final rule. The FTC may still act against non-competes in this different context, but in this rule, they took a pass on it. So the rule, I think, in many ways is a model of good antitrust policymaking, a careful grappling with the empirical research, a thoughtful and detailed response to counterarguments, including employer justifications for using non-compete clauses. And the FTC, in my view, correctly concluded on net that these contracts are both harmful to workers as well as to downstream product and service market competition, and declared these contracts to be per se illegal. So, of course, that still raises the question, does the FTC have the authority to write this rule? It may have all the evidence in the world, but if it doesn't have the statutory power to write the rule, then it doesn't matter. But I've looked at 6G many, many times now. I've read National Petroleum Refiners many times now. I think it's one of those decisions from the 1970s that's routinely caricatured. People don't honestly present what it concluded, its reasoning. And so let's start with 6G. 6G says the FTC shall have the authority to make rules and regulations for the purpose of carrying out the provisions of this subchapter. In this case, the subchapter being the FTC Act, including Section 5 and its prohibition on unfair methods of competition. And the National Petroleum Refiners decision actually took that text very seriously and said, the text looks pretty clear and unambiguous to us. We don't really need to consult the legislative history. We don't need to consult the broader policy considerations. But for whatever reason, the DC Circuit still went ahead and did that, really took a belt and suspenders approach and said, the FTC wins here on textualist grounds, but we're also going to consider the policy rationale for the FTC exercising this authority. And so Maureen refers to modern approaches to statutory interpretation. So I'll quote Justice Gorsuch in the 2020 Bostock decision. He said, speaking for a 5-justice majority, when the express terms of a statute give us one answer and extra textual considerations suggest another, it's no contest. Only the written word is the law. So I just recited the text of 6G. I just recited what Justice Gorsuch said in 2020. To me, 6G is pretty clear. There's no need to even consider extra textual sources because the language doesn't have any ambiguity. The FTC should win on textualist grounds to the extent that these textualists are consistent with their professed principles. Another point is Congress supposedly doesn't hide elephants in mouse holes. It's kind of a funny line. It's, Scalia clearly had a knack for humor, but in another, I think, more critical way, this is a good illustration of judicial arrogance. Scalia is saying, Congress has to structure statutes the way we would structure them if we were standing in their shoes. If they put a rulemaking provision in this section as opposed to another, we're going to treat it with skepticism. And that's frankly not a judgment that the courts should be making. Congress has expertise on drafting legislation. It can decide where to put rulemaking provisions where it wants. It's not for judges to second guess. Last but not least, one point I'll say to critics of the rule is, under established administrative law principles, the FTC can make policy through one of two ways. It can do rulemakings using its 6G power, or it can make policy through adjudication. And the Supreme Court in decisions like Chenery and Bell Aerospace has said the agency has discretion. If the FTC, in this case, wanted to announce a per se ban on non-compete clauses through adjudication, it could have done that. And it didn't, and I think it wisely didn't, because rulemaking is a much better way of making broad policy. The FTC can review all the evidence as opposed to a discrete set of facts. It can and indeed has to solicit public input. And so policymaking through rulemaking strikes me as generally superior through policymaking through adjudication, where you're just talking about two parties, FTC staff versus a defendant, rather than everyone getting to participate, weigh in. A comment letter doesn't have to be anything elaborate or formal. It could be a one-paragraph PDF. Everyone can participate, whereas that's not the case with adjudication. So for critics of rulemaking, they should also step back and ask themselves, well, how should the FTC make policymaking? Is adjudication the better tool? And I would argue that, in general, rulemaking is the better tool here. And, ask the question about, this being a subject for state law. Congress can regulate non-compete clauses and a variety of contractual provisions under its modern Commerce Clause powers. That's not really debatable. The FTC is a creation of Congress. The FTC has broad powers accordingly. So maybe there are policy arguments why this should be exclusively a matter of state law. But as a constitutional matter, Congress and the FTC have the power to regulate and even prohibit these contracts. And states, for all their virtues, are still subject to the Supremacy Clause. And so federal law trumps contrary state law.
Just on the question of the courts, there is a separation of powers. We have a constitutional structure. And so it is not the case that Congress can do essentially whatever it wants through whatever form it chooses. It has requirements and strictures, and that the courts have always imposed on Congress. So I think that's just a very normal thing for the courts to do. And for preemption, the question is not, can the federal government preempt the states? It's, has it been clearly articulated that this statute is doing that? And that's the analysis, right? There's field preemption, there's subject matter preemption, there's clear. So when you look at, say, for example, COPPA, the Children's Online Privacy Protection Act, Congress didn't just not say anything about it. It was presumed that the FTC, that Congress, and then the FTC's rule preempted the states. It was explicit that it preempted state laws. So I think that the question isn't whether they simply could theoretically have the authority to do it. The question is, was it clear in the way that this authority was granted to the FTC by Congress to do this?
Okay, where do each of you think the FTC might take the policy statement and its rationale next in terms of enforcement focus? And I'll just throw out a few things that have been written about in this respect. AI, exclusive dealing would be two, maybe price discrimination. But do either of you have any thoughts about that? And I'll start with Maureen.
Well, if the FTC is able to establish that it has this broad rulemaking authority paired with a very, very broad articulation of an unfair method of competition, I think the temptation will be to use this authority to sidestep any Sherman Act or Clayton Act case law that the administration doesn't care for, right? So you could kind of go back and change essentially, antitrust law. So yes, exclusive dealing. There have been petitions put before the FTC to prohibit exclusive dealing with very low market shares. Like, under Sherman Act case law, you have to have, market power to show it without market power. You can have, sort of the list goes on and on, I think, case law that people just didn't at the FTC or, folks more broadly just didn't care for where the courts came out. So I think there's really a temptation to use UMC as just a tool to change case law without having to, go to Congress to get the antitrust laws adjusted. We saw a big push a couple summers ago to change antitrust law. I think that would be a template for future FTC UMC rulemaking.
Sandeep, any thoughts about where the FTC might go, or where you think maybe they should go?
Yeah, I think vertical restraints are an obvious target, exclusive dealing, maybe some price restraints. And, I should emphasize what I said at the opening. In decisions like Sylvania and Legion, the Supreme Court was interpreting the Sherman Act, not the FTC Act. And the court has repeatedly said the commission can prohibit practices under the FTC Act that don't necessarily run afoul of the Sherman or Clayton Act. So the FTC isn't bound by Sylvania, even though we often treat it as reinterpreting the antitrust laws broadly. That was an interpretation of Section 1 of the Sherman Act and nothing more than that. And even in Sylvania, I would argue that the FTC actually has some wiggle room to declare certain vertical non-price restraints as per se illegal. So, I'm quoting Justice Powell's decision in Sylvania. He said, "We do not foreclose the possibility that particular applications of vertical restrictions might justify per se prohibition under Northern Pacific Railway, but we do make clear that departure from the rule of reason standard must be based upon demonstrable economic effect rather than as in Schwinn upon formalistic line drawing." So there's actually a pretty decent argument to be made that non-compete should be per se illegal under the Sherman Act based on the evidence that the FTC has compiled. The FTC didn't wake up one morning and say, hey, you know what, we're going to ban non-compete clauses for everyone. It spent years doing this rulemaking, compiling the evidence, considering the counter arguments, evaluating its statutory authority before putting out the proposal, never mind the final rule. So I think vertical restraints more broadly could be an important way to go forward. Maureen made an interesting point about non-compete clauses. She's right. They have long been the stuff of antitrust law. So it is easy to overstate how novel the rule is. And if you go back to the history, if you go back to the pre-Sherman Act common law, arguably non-competes were the original restraint of trade. This is something that Judge Learned Hand recognized in the Gardella versus Chandler decision about baseball's antitrust exemption in 1948. He said, non-competes are classic restraint of trade. So, for all the talk about the novelty and unprecedented nature of the FTC Act's action here, they're actually in some ways going back to the original history of antitrust law. So that's actually a helpful fact in pushing back against the major arguments. But I realize I'm on a little bit of a tangent here. Another area where I could see the FTC being active in using Section 5 is going after some of the practices used by pharmaceutical companies when it comes to patenting. So they've already done some work around the abuse of the FDA Orange Book process. I could see them building on that, maybe bringing a case against companies for abusing the Orange Book notification system. I could see them using Section 5 to go after abusive patenting practices more broadly. We've seen a number of Sherman Act lawsuits against pharmaceutical companies that have indiscriminately filed patent applications in the aim of building up a patent thicket to keep out generic entry. That could be a useful and worthwhile target for Section 5. So, broadly speaking, I think vertical restraints and patents will be an area of focus for the FTC.
Excellent discussion. So we'd like to close these episodes with key takeaways for practitioners. And Commissioner Ohlhausen, let me start with you. What is your key takeaway here?
I think there are several key takeaways. First, that the FTC is looking to push beyond the boundaries of traditional antitrust law to claim a much broader regulatory authority, kind of a direct regulatory authority of the economy. So you need to pay attention to what targets they've identified and what areas they have said they would like to go into next as you counsel your clients. I think don't think just because you're not involved in the non-compete issue that this rulemaking is something that you can just, ignore. Because if the agency gets this authority upheld, it will be the template through which it will make all these changes to the boundaries of antitrust law that it has identified in speeches and policy statements and enforcement and actions like policy statements and letters. That will be kind of the new tool to make their policy preferences binding obligations on business.
Sandeep, what are your key takeaways for our listeners?
Sure. So I'll offer three key takeaways about the FTC and unfair methods of competition powers broadly. So first, we're seeing a return to law. The FTC is taking statutory text, case law, legislative history seriously again. So we've lived in a multi-decade period where courts and even the agencies have treated antitrust law as a little bit of a blank slate. They can make policy based on theories that are in vogue, offered by both economists as well as lawyers who would like to be economists. Law has been not necessarily pushed to the side, but I would say at the margins relative to economic theory. And that's changing under this FTC, which is certainly very positive. Second, we're not by any means seeing an abandonment of economics or social scientific expertise. Rather, we're seeing a focus on empiricism as opposed to theory. I think the FTC non-compete clause rule is a model of that. The FTC exhaustively reviewed the literature, consulted the experts, solicited input from the public. The public offered important evidence to support the final rule, sharing their own experiences. And we're not talking about 10 or 15 or 20 comments. We're talking about tens of thousands of comments where people, both employers and employees, share their experiences with non-competes, how this has affected them adversely or otherwise. So we're seeing a full-throated embrace of empiricism as opposed to arid theory. Third, this is a little bit of prediction, even maybe wish casting on my part, but this rulemaking and policy statement could be the start of a more administrative approach to antitrust, where the FTC as an expert agency becomes a key or the key policymaker on competition policy, as opposed to judges who both life tenured and lack relevant expertise. So in many ways, this could be the beginning of antitrust resembling other areas of federal law rather than being this weird exception that has persisted for more than a century.
Scott, do you have any takeaways for our
I
listeners?
guess I have one principal takeaway, final takeaway, which is stay tuned. I think, there's a lot of questions about whether these rules will survive challenges in court. Also, what the impact would be of if there's a new Republican administration after the election. So, I think we'll have to wait and see, for instance, with the non-compete ban, whether it's going to be permitted to take effect. So I do think there are, some questions about, whether these policies will survive and become perhaps a template, as Sandeep is suggesting, or whether it will be something of relatively short duration. And in the case of the non-compete rule, possibly not be allowed to ever take effect.
Could I add just one point, something we haven't discussed here, but I think is really another important part here, is we haven't talked about what this means for dual oversight of antitrust enforcement when you have the Department of Justice, who also shares antitrust oversight. And so if it's going to become an administrative approach to antitrust law, what does that mean for that current system? I think is maybe the topic for a future podcast, but I think it raises some very interesting issues.
Well, whenever we have a topic where I get relatives and friends who are not even in antitrust talking and having opinions and asking me questions, I know that we have a good topic, and it was great to do this episode. So thank you, Scott, for co-hosting this with me. To the Honorable Maureen Ohlhausen and Sandeep Vaheesan, thank you for this illuminating debate on the proper scope of the FTC's Section 5 authority and the prospects of the FTC's non-compete ban. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.